Good morning, all, and welcome to the Richardson Harman Ober web seminar for June 23, 2015. We still have people signing on as we speak. I hope you found the pre-show interesting. Today's presentation is slated for 45 minutes of prepared remarks, and at almost exactly 12:15, I'll stop and we'll take it over to questions. If you have questions today, if you could please put them in the question box. Please do not try to put your questions in the chat box, and I will field as many questions as I can at the end of the presentation between 12:15 and 12:30. This morning's presentation is focused on fair housing and the Homeowner Association manager, director, or homeowner. Today's topic involves state and federal law. There is the Government Code Section 12900 through 12996, as well as federal law. Let's talk about who enforces the fair housing laws in our state. We have a combination of actually four different entities or four different groups that enforce fair housing in the state of California. We have, of course, the federal government, the Department of Housing and Urban Development. We also have the Department of Justice will enforce fair housing. We have the state level. The Department of Fair Employment and Housing is a specific department that enforces fair housing and anti-discrimination laws in the state of California. The Attorney General of the state of California also can enforce fair housing laws. But we don't stop there. There are local enforcement entities. There are nonprofit organizations throughout California called fair housing councils or fair housing rights groups. These are nonprofit organizations that are in existence to help people deal with discrimination problems and, when necessary, to file lawsuits against offenders seeking not only court orders correcting the bad behavior, but also attorney's fees. And of course, attorney's fees as well as government grants are a significant part of their revenue. But there's a fourth group of enforcement, and that's the general public. Any individual can file their own lawsuit to enforce fair housing laws, and I think that's one of the areas that people get upset about are the stories about people going out and looking for violations. Well, that depends upon which side of the table you're on, I suppose, because if you're a person that is disabled, people that are going around policing, finding violations, probably are viewed as heroes. Those who operate or own properties and get hit with these lawsuits, of course, view these people as opportunistic. But the individuals can also enforce fair housing laws. A quick overview of the fair housing laws in our state. I've already mentioned the California FEHA, Fair Employment and Housing Act. That begins at Government Code Section 12900. It's been around for about 35 years. It created the Department of Fair Employment and Housing and the Fair Employment and Housing Commission. A couple of years ago, the commission was reformed into the Fair Employment and Housing Council, which is a group of 7 appointees of the governor who are tasked with establishing fair housing and fair employment policies in the state of California. An interesting statistic that hopefully will be very instructive to you is that housing complaints are a small slice of the total complaints filed with the Department of Fair Employment and Housing each year. Yet, up until recently, 30% of the housing complaints were prosecuted. In other words, much larger percentage of action is taken on a housing complaint. The likelihood now is up even more because at the last report we received just a few months ago from DFEH, now it's up to about 40% of the housing of the complaints acted upon by the DFEH are housing, even though there's still a fairly small slice of the complaints received. Here's a quick snapshot of the actions of the Department of Fair Employment and Housing. This is courtesy of Kevin Kish, who was recently appointed by the governor as the new director, replacing Phyllis Chang, who did a wonderful job for years running that department. Look at that highlighted number set in the middle for fair employment and housing complaints. it has doubled. The number has doubled in the 3 years between 2011 and 2014. So this is an increasing area of issue and concern for anyone who operates, manages, or owns real estate in the state of California. And the general public, I think, is becoming more and more aware of this. So something we really need to understand. Here's a breakdown, again, statistics distributed by Director Kish in March of this year. Housing complaints filed in 2014 by the department, 1,524 of them. But look at the key 4 areas where most of them are being issued. Mental and physical disabilities, number 1. Second place, race and color. It's amazing to me in 2015 we would still have people violating the restrictions against race or color discrimination in our state. But there you go, 475. And then retaliation. And then lastly, familial status. Look at that, 252 complaints last year regarding familial status. So that gives you an idea of where the problems are. Another problem that we have in housing is, where do we go to do it right? That, as a lawyer dealing with real estate law, primarily causes me a lot of difficulty, because this is one area of law where we don't have guidebooks. We don't have lots of cases decided by the appellate courts in California that are published to guide us. We don't have yet any specific instruction from the state of California on fair housing regulations. I'll be coming to that a little bit later. Hopefully that will change this year. But what we have, the scant authority that we have, or the scant guidance we have to go on, comes principally from anecdotal information, press releases from the DFEH, people who have made bad mistakes in their decisions about managing housing, and sort of a don't let this happen to you type of learning. Well, that's not a very effective way to help people learn how to do it right, because those tend to be the real extreme cases. We need guidance on how to, not how to be extreme, but how to do it properly. HUD, the DFEH, other stakeholder organizations also issue in seminars, publications, but they're not binding. They're merely guidance, education. Lastly, probably the most significant resource that we still have are 2 interpretive guides from the Department of Justice and the Federal Housing and Urban Development Department, interpretive guides on how to comply with fair housing and accommodating disabilities. But then let me show you, here's the cover sheet of the most recent one. I've highlighted for you the date of this. This is the most recent joint statement of the Department of Housing and Urban Development and the federal DOJ on modifications. Do you see the date there? March 5th, 2008. That's the most recent statement we have. There's another version of this. It's actually different. So I tend to look at both versions. I think from the year 2004. I've given you both links in the second page of your handout materials. And by the way, I checked all those links literally last evening to make sure that each and every one of them still is valid. So this joint statement, which is over 50 pages long, is one of the only things that right now in the state of California that gives us any kind of specific guidance at all to try to learn how to do things right, which is a big challenge. So there's a lot of frustration here. And of course, there are lots of stories of abuse, case histories of people using fair housing laws as a sword instead of really getting help. And of course, that creates further frustration. Another continuing problem that we have is distinguishing the fair housing laws from the Federal Americans with Disabilities Act, and we have a state equivalent law now as well. But they're two very different. First of all, fair housing laws apply to private entities. The Americans with Disability Act specifically applies to public accommodations. And by public accommodation, we don't mean a property that is not a security building where anybody in the general public can walk in to deliver a package or knock on a door. By a public accommodation, we're talking about typically restaurants, offices, retail businesses, places where the general public is invited. Your association, whether you live in it, whether you operate it on the board of directors, or you're a manager, the fact that your association may not be completely fenced off or may not be a security building doesn't mean that it's a public accommodation. The one case we have on this, which involves the ADA, not fair housing, is the Evan Carolyn versus Orange Park Community Association case from 2009. That was an interesting case where a gentleman who was a paraplegic had a horse-drawn cart that he liked to have pull him around for recreation. Well, Orange Park is a wonderful association in Orange County that is very fortunate to have miles of equestrian trails, but they can't lock the equestrian trails off. They put little barriers to make sure motor vehicles can't get on there. And they said to Mr. Carolyn, well, I'm sorry, Mr. Carolyn, by the way, who was not a member of the association, they said, sir, you can't bring your cart on these equestrian paths. They're meant only for horses who are being ridden. And he claimed that the horse trails were a public accommodation, and the Court of Appeals in that published decision said, no, they're not a public accommodation. These are still private, even though they're not completely locked off. So keep in mind that fair housing is very different from the ADA. The ADA, for example, typically the types of things that are required by the ADA are not terribly expensive modifications to public accommodations, changing sink faucets, changing counter heights, changing parking signage, making sure the handicap spaces are there and properly marked. And one of the defenses to the ADA complaint is that it is impractical, or it's a very substantial expense or problem in trying to comply. So, for example, a historic building will have all kinds of ADA violations, but they have a defense that they can't be required to demolish their building. Fair housing law doesn't have that same defense. Fair housing laws first, again, apply to private entities. All of you that are in common interest developments, it applies to you. Oftentimes we think of fair housing as more of a landlord issue, but it applies to common interest developments as well. And in fact, the term that is often found in the fair housing laws is the term housing provider. A housing provider is not just a landlord or a lessor, it is also a common interest development. Colloquially, we of course call them HOAs, but homeowner associations or common interest developments are also very much considered housing providers under the fair housing laws in our state. Also, the manager of that housing provider is subject to fair housing and is required to comply. And this is going to come up, I think, more and more as we're looking at the regulations that I'll be addressing in just a few minutes. So, Homeowner Association Board, don't think that because you're a private community that you don't have to worry about fair housing. You really do. The laws apply to you as much as the apartment building across the street. There are many bases of protected housing or anti-discrimination, protected classes in our state. Of course, the big three are disability, race and color, and familial status. Those are the three big violation areas. There, of course, is sex, sexual orientation, marital status, religion, source of income. You know, I used to joke that the one group that you could discriminate against legally was attorneys, and that would always get a big laugh, but actually that's not true. You're not allowed to discriminate based on how someone makes their living, so long, of course, as they're not making their living doing something illegal. Medical conditions, age. You can't have age restrictions, although we do have a special category of housing in California, age-restricted communities. And then some relatively new categories, gender identity and gender expression, and genetic information. Now, of course, gender identity, gender expression is all in the news right now, but that's been a protected classification in California for, I think at least about 6-7 years now. The definition of gender expression, that is really referring to a subcategory of sex discrimination, that how somebody sees themselves, how they express their sexuality cannot be a basis for your making a decision to allow someone to live in your community or not, or as to whether they'll be disciplined or not, or anything else. You basically have to ignore it. Genetic information refers to specific genetic issues. Somebody has Tay-Sachs or sickle cell or something like that. That cannot be a basis of denying them or otherwise making decisions regarding housing. One thing you may not have known is, kind of makes sense though, is that a housing provider, a landlord, and remember, commoners, developments, boards, or in this context, landlords, cannot subject the residents to sexual harassment. Now that seems to make sense, but that falls under fair housing and fair employment as well. Here's an area, though, that becomes troubling. Does that mean that a commoners, development manager or board has an obligation to protect residents in the community from unwanted sexual advances by another resident? That's a little frightening, and that's going to come up in a minute when we talk about the regulations, because that's exactly at this point where the draft fair housing regulations are going. The most common discrimination by commoners developments, I think in California by far, is familial status discrimination. This is where associations are making decisions, policies, operating rules which discriminate against the presence of children in the community. That's a problem. And usually the desire of the association is not really to harm children. It's usually to try to deal with problems in behavior issues. But you can't restrict children. You can't discriminate against children. What can you do involving children that isn't a discrimination of familial status? Well, housing providers can, and I put question marks because it's nowhere written down in any regulation or court case, but there is a tradition that a landlord, including homeowners associations, can limit occupancy in a given residence to 2 per bedroom plus 1. The idea there is that you'll have a couple in each bedroom. One couple may have a small child sharing the room with them. So a 2-bedroom unit could have 5 people. So you could safely limit occupancy in a given housing unit to 5 people for that 2-bedroom, and you should be okay. The problem, though, is that nowhere is that in writing. That is a tradition. In the draft housing regulations, that is going to be written down, so we'll finally have some confirmation that that's okay. But I was talking to a homeowners association just this week, and I found out they had a restriction of 2 per bedroom, and that is also a municipal ordinance in their city. Well, the problem with that is that that's more strict than allowed by the fair housing laws. So I don't know what's going to give way here, whether the association can sit back and wait to see somebody challenge the ordinance, or whether they're going to take the safe route, and even though the city says you can only have 2 per bedroom, they should allow 2 per bedroom plus 1. There are some rules involving children that are okay. In fact, there's state law that says that your commoners development pool, you have to have children, I think it's 14 or under, supervised by a parent or guardian. That's specific law. So there are some very limited circumstances where you can have a rule with dealing with children. Again, it's a big problem with rule drafting. If your association is worried about safety, worried about noise, and for example, you ban skateboarding by children, or children cannot use skateboards in the courtyard. Well, sure, most likely we're thinking about children are going to be the ones that are riding bikes or riding skateboards in the courtyard. But does that mean that if Tony Hawk, the all-time famous skateboarder, was in your community, that he could skateboard all around the courtyard and it would be okay? Well, of course not. Of course not. So check your operating rules. Make sure that you don't have restrictions that are singling out children instead of focusing on the activity. That's all you have to do. CC&R's operating rules shouldn't discriminate against children, shouldn't single out children. Focus on the activity, and you're much more likely to be on safe ground. The other area that associations wind up battling and unfortunately finding themselves in situations far too often are dealing with disability discrimination issues. Well, let's talk for a moment just about what is a disability under California law. A disability is a mental or physical impairment, disorder, or condition that limits a major life activity. That's a disability. Major life activities include a variety of aspects of life. It's very, very broad. If someone has a record of having or is perceived as having a mental or physical disability, that can be considered disability. And disabilities can be permanent, but they also can be temporary. Here's the rule on dealing with disabled persons. Housing providers, upon the request of a disabled person, must allow a reasonable accommodation unless you can demonstrate an undue financial or administrative burden or a fundamental change in the nature of your housing program. Now, that's the reasonable part of reasonable accommodation. If the accommodation truly is unreasonable, then you can deny it. A couple of caveats, though. When you say unreasonable, make sure that you're absolutely sure that somebody outside your association who doesn't know you, who may be suspicious about homeowners associations and their boards, is going to agree with you. Please don't call something unreasonable when it's a 51 to 49% call. That's a really bad idea, okay? If you're going to be saying it's unreasonable, make sure that it really truly is unreasonable, not just that you're, quote, making a case that it's unreasonable, all right? Secondly, you can request verification from a medical provider that the person is disabled and has a need for that accommodation. By the way, medical provider does not just mean doctor. It is very, very broad. Could a orthopedic doctor present your homeowner with a letter saying that they have an allergy that requires them to have an accommodation in regard to whether they have carpets? Yes, there's no requirement that the medical provider specialize in that specific area. So that's a little bit of a problem right now. But if somebody rolls up into your board meeting in a wheelchair with a cast on their leg, that's an obvious disability. You don't have the right to demand documentation about that. You can see they're disabled. They rolled up in a wheelchair with a cast. You're not entitled to specific information about the nature of the disability. The only thing you need to know is there is a disability. And the accommodation is not just dealing with things like adding a ramp or allowing somebody to widen their doorway. It could be changing your rules or policies. And a lot of time our associations are getting into that issue, is they're saying, well, we have a rule assigning our parking spaces, or we have a rule saying that this is how we handle something. We have a rule or something in our CC&Rs that says there's no pets. Well, those rules have to bend unless we can show a specific reason why the bending is unreasonable. And let me tell you what, if you're talking about a policy, most of the time unreasonable is going to mean that it's creating a nuisance for other people. What you think is reasonable is not what the fair housing world thinks is reasonable. All right? So the test is really, is it unreasonable? Okay, so again, disabilities are confirmed. Well, you may not be entitled to request any confirmation whatsoever. You can use your own eyes and see somebody has a problem. You are entitled, though, if it's not obvious, and that comes into play with, you're talking about allergies, you're talking about emotional need for a support animal. Those are things you're allowed to ask for documentation from a healthcare provider. Here are some of probably the most common accommodation requests that I see all the time. Making an exception to an association's no pets policy to enable a companion animal or a service animal. Another really common one is asking for hard flooring in a multiple-story building where the building requires carpet and pad to protect people underneath from unreasonable noise. The requesting person says, well, I have very severe allergies. I have to have a hard floor. That's a very common request. Now, it's not an easy request, but it's a very common request. But you're really going to have to balance their dealing with the people's protection underneath and figure out some way to accommodate that request. Changing parking rules. Somebody has had a knee replacement surgery, and for the next 6 months they say, I need a parking space closer to the elevator. Very, very common request. And of course, many of you may have dealt with a variety of requests far beyond these, but these are some of the more common ones. Some other examples of modifications to the property, not just the rules, but actual modifying the building, widening doorways to the residents, lowering cabinets, installing wheelchair ramp, things like that are very common requests of homeowners. Generally speaking, the association doesn't have to pay for the modification and generally may require the premise to be restored, although there's some exceptions that we'll talk about in a minute. Here's the general rule, and again, this isn't really written down anywhere, as to who pays for the accommodation. If the accommodation is inside the residence or only benefits one homeowner or one resident, the requester pays. If the accommodation, however, benefits the entire building, somebody's asking for a ramp from the main entrance to the building into the community room, then the housing provider may be required to pay, because that's something that really benefits potentially everybody in the building and their visitors. So be very careful on that. There isn't a bright line, folks. I think that if it's clearly inside the unit, I think it's pretty clear the homeowner's going to pay or the requesting tenant's going to pay. If it's outside, you may think that it only benefits one residence, but be careful, because the fair housing enforcement people in a dispute situation may say, wait a minute, there are other people that be walking through this area, so even though one homeowner is asking for it, maybe the association is going to need to take care of that ramp to benefit more than just the requesting party. Another common question is, can we compel the tenant or the resident to restore the accommodation when they're done? Well, again, inside the residence, and this comes from the Department of Justice HUD guide that I referenced earlier in this presentation, if the accommodation is inside the residence and it is non-structural, then yes. For the most common one is going to be somebody puts in an insulated, cushioned, hard flooring surface to deal with their allergies. Well, you can require that they take it out when either their allergy abates or when they leave the residence. That's certainly something that you can do and probably should do to protect the people from downstairs. If it's, on the other hand, a structural issue, they're widening doorways, the entry door, doors to the bedrooms in the residence, then per the DOJ guide, you're probably not going to be able to ask them to restore it. And really, why would you need to? It doesn't hurt anybody to have the wider door and the wider doorway. Common area alterations, you're probably not going to be able, first of all, the resident probably didn't pay for it, the association paid for it, so you're probably not going to be able to ask if that be restored. And once again, if it improves the property, makes it more accessible to the elderly, to the disabled, then why would you want to take it away, right? Here's an area of a lot of dispute, a lot of growth in the issue, but at the same time, a lot of misunderstanding. Animals. There are two categories of animals. There's the ADA service animal. A service animal is far less common. Service animals are specially trained animals designed to perform a specific function. They are usually certified by agencies, and under federal law, the only recognized service animals are dogs or miniature horses. So somebody says, I have a registered service animal and it's a cat. Well, it's not a service animal. It may be a companion animal, and they may be calling it the wrong thing. And I'm going to tell you two times out of three at least, you're going to find your homeowners or your tenants are calling an animal a service animal. They've got a letter from their therapist saying they need this animal for anxiety reduction. Well, they're really not talking about a service animal. They're talking about a companion animal. Just because they have the right to a companion animal or the need for a companion animal doesn't mean they get a blank check. If they have a companion animal that's a Chihuahua, and that Chihuahua is barking at 2 o'clock in the morning, they don't have a blank check to make everybody else in the building miserable. You are allowed as a manager or board of directors to have reasonable controls to make sure that the companion animal doesn't become a nuisance for everybody else in the building. So pet waste, barking, menacing people, those are all things that can be and really should be controlled. And you're going to find some people who don't understand this, and they think that the companion animal or the comfort animal note that they got from their therapist, their psychiatrist, their doctor, gives them a blank check and nobody can talk to them about their dog or their cat or whatever. That's just not true. So we all have to work together in this, and sometimes you're going to get people that need to be educated that, okay, we're glad to cooperate with you, but you need to cooperate with us too in this accommodation of this companion animal. There is a lot of abuse of this. I'm not going to pretend otherwise. At the same time, there are lots of people who it just seems like the two easiest things to get these days from your friendly local social worker, nurse, doctor who's a friend, is a medical marijuana prescription and a companion animal note. So there is a lot of abuse here, but the bottom line is if they get a note from a healthcare practitioner of some kind that they need a companion animal, they're going to get the companion animal, but you can again restrict the activities or the way the companion animal behaves so that it doesn't threaten or other people or damage the property. Another huge area where we just don't know how the law is going to sort out here is the growing trend of no smoking buildings. Oh my goodness, no smoking cities. I'm sitting here today in the city of Pasadena where the city council a number of years ago adopted an ordinance that bans smoking in attached housing, period. Condos, apartments, duplexes, if it's attached housing, it's a violation of city ordinance to smoke inside your home. At the same time, though, we have medical marijuana use where a lot of folks that have medical conditions of a variety of natures have a medically documented need to smoke marijuana. How are those two colliding interests going to be resolved? We really don't know. There is the current draft regulation of the Fair Housing Regulations that was issued in December by the council right now gives a blanket right to smoke medical marijuana. Well, I think that's not going to be helpful as is, because we're going to start having clashes between people who are saying, I don't want my tenants or my children subjected to secondhand smoke of any kind, whether it's a medical necessity, whether it's tobacco or marijuana or something else. So stay tuned on that one. I'm not going to pretend to have an answer how this is going to be handled. The Fair Housing Regulations I just mentioned, these were, this is a landmark legal event in the state of California. I have said many times in the last 6 months that I think it's very likely to be the biggest development in California real estate this year, that it's going to be bigger than anything the legislature is doing in terms of affecting how landlords, housing providers handle their real estate in the state. The first draft was issued in late December 2014 by the Fair Employment and Housing Council. It is available from the Fair Employment and Housing Council website. The simplest way to find it is just go to www.dfeh.ca.gov. I've given you the link on the second page of your materials. If you click on the lower right-hand corner of the website for the Department of Fair Employment and Housing, you'll see a commonly used links. One of them is for the council. Click on the council link, then click on meetings and agendas. Go to the January 2015 meeting and then look at the attachments to that meeting agenda, and you'll see the draft regulations there. They're quite lengthy. I think they're over 50 pages long. They are a kind of a rough draft. I think it'd be the fairest thing I could say. The draft has not been discussed in the last couple meetings at all, and we're waiting to see exactly what is going to happen in terms of when the next draft will issue and what it will look like. One of the important things I would point out, however, about these draft regulations is that housing managers, so those of you who are listening to this seminar who are managers, either a general manager or a portfolio manager handling a given association, you are specifically governed by these regulations, which means you can personally be sued if you participate in a violation of the fair housing laws in our state. So now that I've got your attention, it really is something that we all need to provide input. The Fair Employment and Housing Council consists of 7 governors, appointees. Really, only a couple of them have any involvement in the dealing with real estate and disabilities, and they are not real estate brokers or property managers or real estate lawyers per se. So they really need input from the general public, and particularly from those of us who are involved in real estate. And they have, in a couple of their public hearings, they're all public, they meet around the state about every other month, the council members have specifically asked for help and input from the real estate community. So I strongly encourage you to read this. I know it's 39 pages, but look at the draft. You'll see specific sections you might want to pay attention to. For example, the sexual harassment section, point 15 of the draft regulation says that a landlord, which again is going to include the homeowners board and the manager, is going to be required to protect residents from unwanted sexual advances of other residents. Now that's a real problem. In the employment context, that's normal. You can reassign employees, you can even discipline and terminate them if they persist in mistreating their colleagues at work. But you can't fire a condo owner who makes an unwanted advance to another condo owner in the community. So I really don't know how the council is going to resolve this. It's a huge problem as is, because you can't treat homeowners the same way you treat employees in this area. But right now, that's in the draft regulation. Point 16 talks about the liability for that harassment between residents. An interesting component of the draft regulation is an interactive process. The interactive process is designed to encourage complaining disabled persons to meet with the housing provider and to try to figure out, how can we work this out and meet our mutual need? Can we identify alternatives before taking this to the enforcement level, before the DFEH, or even going to court? Point 29 of the draft regulation talks about proof of disability. Once again, there's an extraordinarily broad array of healthcare service providers, including a social worker who can document a disability, and no requirement that the healthcare provider practice in the specific area of the disability being suffered. Another interesting point is that for the first time, the regulation will, if adopted in this form, have the familial status, the occupancy limits, finally recognized as 2 per bedroom plus 1. So those are some of the main sections I want to call your attention to. But there are several areas in the draft that are really problematic. One, of course, is, as I already mentioned, the issue of prohibiting sexual harassment between residents and requiring that the manager or the board of directors take reasonable action on that, and could be liable for enforcement or civil lawsuit liability if you don't. I really don't know how we can police that in the common interest development world. As a lawyer, believe you me, I sure don't want to get involved in that. Second issue is the blanket approval of medical marijuana in the draft, not really accounting for no smoking ordinances, and again also the vast array of health service providers and no requirement that they be connected to the specific disability being claimed. On this screen, I'm just pointing out a variety of rather significant issues which are not addressed in the draft regulation. Defining nuisances as an unreasonable accommodation, it's nowhere in the draft. You would think that that would be the most fundamental example of what is not a reasonable accommodation. But unfortunately, that isn't in the regulation, and I really think it should be, but maybe you have your opinions that you could also provide the council on this. The cost of the accommodation, I would have hoped that we in the state of California would at least follow the lead of the DOJ and at least, if nothing else, adopt their guidelines in terms of who pays. But it's not addressed at this point in the draft regulation. How can a housing provider require that the accommodation be restored? And what kind of accommodations cannot be required to be restored? That's something we very much need. It's not addressed. What about common area accommodations? What is the test to trigger whether or not a landlord pays for an accommodation? That's not covered in the draft regulation. There's no reference to temporary disabilities or temporary accommodations. If there's a temporary disability, doesn't it make sense that you could ask for an update? If somebody has a temporary disability that is predicted to last 6 months to a year, after a year or so, wouldn't it seem reasonable that the housing provider could request from the individual, hey, can I have an update? How are you doing? Is your disability continuing? Or can we return things back to normal? That's not covered. The ability to have a safe harbor for compliance. One thing about these fair housing regulations, they are going to be very helpful in that for the first time they're going to give us some guidelines on how to do things properly. but they also clearly are also they're going to provide a vehicle or they're going to expose people to liability if they do it wrongly. Well, shouldn't there be a safe harbor in there saying that if you comply with these standards that you cannot be sued under the standards? That's not addressed. Lastly, and to me, most interestingly, there's no definition or limitation on the so-called comfort animal. Now, while we talked about service animals, which is pretty narrow category, and those are dogs or horses under federal guidelines, a comfort animal right now could be anything. It could be a dog, certainly the most common. It could be a cat, okay. What about a monkey? What about a chimpanzee? An iguana? A hamster? What about a rat? Would you get a letter from your therapist that says, yes, the rat is a comfort animal and my client has the right to this rat, and so they go into Denny's with the rat on their shoulder at the table next to you? It seems to me that we really need some guidance from the psychology or the psychiatric community on giving us some reasonable parameters of what really is a comfort animal. None of these things are addressed. Again, the Fair Employment and Housing Council very much wants input, and please feel free to provide your own input after you've looked at the draft regulation on this. I was at a board meeting a couple of years ago. One association, we had two different homeowners showed up at the meeting. It was a fascinating encounter. One of the individuals was a man who showed up at the board meeting having written a number of vociferous letters demanding that he have accommodations and saying that he was unable to walk. And this person was threatening lawsuits and threatening complaints to the Fair Employment and Housing authorities. And one couple of little details, though, that weren't mentioned at first. This board meets in the second floor of a building that has a very steep and long stairway to get to the second floor. This gentleman had no problem maneuvering the stairs. Anybody attending the meeting could see that. The second thing was that he was in an association that didn't allow parking in their driveways. The driveways are too short, and so people were required to park in their garages. Well, this gentleman had items in his garage, and he was demanding that as an accommodation, he be allowed to park on his driveway or out on the street. They also had restricted parking on the street. And so the association board listened to his complaint, listened to his threats, and of course, he never mentioned the fact that he was asking for the right to park actually further away from the entry to his home than if he just simply used his garage. So that was the one request. The other request was an individual who came to the meeting asking for parking passes. It was a fascinating and very poignant situation. This husband and wife had a very severely disabled daughter who needed 24-hour care to keep her alive. And this husband and wife simply wanted some extra temporary parking passes for the caregivers so that they could from time to time go away for a day or two or could go away for the evening, and the caregiver was able to park on the street so that literally their daughter's life could be sustained. She never invoked fair housing. She never asked for anything except some more temporary parking permits for the caregiver who was keeping her daughter alive. Well, we went into closed session, and the gentleman who wanted to park his car further away, we didn't tell him no. We said, sir, we'd like to meet with you. We'd like the manager to come talk to you about about how this is going to help you to park farther away. And you know what, folks? Interesting, this homeowner never followed through with that appointment. So that issue very quickly ended. The other person, though, didn't even know she was making a fair housing accommodation request. But by golly, managers and board members, you have a responsibility to recognize when legitimate requests are being made. And I couldn't think of a more worthy situation than somebody who has a loved one so disabled they literally needed care to stay alive. And of course, the board in that instance gave her more than what she asked for. They said, ma'am, we will. They sent her a letter and gave her a full unlimited parking pass for the caregiver. Now, wonderful examples of the kinds of things you're going to deal with all the time as managers and board members in fair housing. You're going to deal with requests that it's very hard to treat respectfully because they're so obviously abusive. But then you're going to have those homeowners who come to you, and they may not even use the right words. But we all have a responsibility to recognize people that need help and give them the help that they need. A couple of closing points on responding to an accommodation request. Perhaps these are just self-evident, but let me suggest to you, when you have an accommodation request come in, first of all, is an accommodation being requested? They may not even use the word accommodation, but like this woman, they may present you with facts where it's clear that an accommodation is being requested even though they're not using the right words. Is the disability obvious, or are you entitled to documentation? Next, what harm does the accommodation do to anybody else? Does it hurt anybody to give them this accommodation? If not, then shouldn't that end the discussion? If it doesn't bother anybody, why not let them? Next, is there any cost to the accommodation, and is the requester agreeing to pay? You know, it's amazing how often that when people make requests for accommodations, as soon as I tell them, well, certainly let us know exactly what you propose to do, and then they ask, well, won't the association pay for it? And depending upon the circumstance, if I say no, the association isn't required to pay for it, all of a sudden they go away. So they want it as long as everybody else is paying for it, but once they are told they have to pay, a lot of these requests go away, which kind of lends some insight into what's really happening. Does the accommodation that's being requested relate to the disability? Does it respond to the disability? Or like this one man, was he really just asking for an indulgence that actually made him walk farther to his home? Can the accommodation be restored after the need ceases? Is there some other reasonably satisfactory alternative than what the person's asking? And most importantly, did you respond appropriately, and did you respond in writing? Please remember how you respond, what you write to these homeowners, what you put in the minutes. These are all evidence of of how you treated this person. And do you think that generally the fair housing community is sympathetic towards homeowner associations? Well, no, let me help you out. They aren't. They aren't at all. So be very careful. Make sure that when you write something, that if the fair housing authorities or a court saw that you are absolutely doing and saying the right thing and doing and saying it the right way. Why is fair housing important to me? Well, you may have seen in the rotating slides before this presentation, you may have noticed this wedding picture. It's one of my favorite pictures. The woman on the right is my daughter-in-law. This is from her wedding day a little over 2 years ago. The man on the left side of the picture is a wonderful man, her dad. And it's fair housing laws and the Americans with Disability Act that allows him to live at least more close to a normal life than he otherwise would. And when you've been with somebody who can't go to certain restaurants, who has to check before he goes to somebody's house to make sure he can even get in there, you really begin to have a different view on how critical fair housing is for survival. I realize, folks, there are abuses, but this is about people who need help. And sometimes we need to step back from the personalities and ask ourselves, do these people need our help? Can we help them? And is there a reason why we're not helping them? A lot of times when you approach it that way, you're going to find your fair housing decisions become much easier than they were before. Well, I really appreciate your listening. We are now at the 50-minute mark. We have a few minutes set aside for questions. I want to thank you again for attending. Those of you who won't be staying for the questions, that's fine. Our next seminar will be on Wednesday, August 12th at 11:30 a.m. And before you sign off, please help me out. I'd like to know what you think would be a valuable seminar for you to listen to, for your management company, for your homeowners board. What would you like to hear? I'd love to have an email from you or a comment in the questions box here. And Matt Ober and I will look at these carefully And we're going to pick our next seminar topic based on the input from all of you. I'd love to know what you want. So with that, let me open it up to questions. I appreciate many of you I see have already asked a number of questions, and I'm going to try to roll through these. I'm just going to start through them in no particular order. You've got a question box on your dashboard. Just go ahead and type away there and press enter. And I won't use your name, but just your first name, and we'll launch into some of these now. All right. The first question from Raymond: as a director of an HOA consisting of single detached homes, are there any concerns in fair housing in this situation? And the answer there, Raymond, is yes. Fair housing applies to detached homes. It applies to any common interest development. If you have a situation where an association in a planned development of detached homes is, for example, has a rule against children riding bicycles in the street, that's a violation of fair housing. If you have a single-family detached homeowner who requests an architectural modification which is designed to help them with a disability, I can think of the most common would be they want to build a ramp from their front door instead of steps. Well, that's probably an example of an architectural modification you're going to want to really take a long look at because that's going to apply to that detached home association as well. All right. June has a question. Is it considered discrimination if an association decides to grandfather out smokers so that no new smoking homeowners are allowed to buy? That's a great question, June. First of all, smoking is not a protected class. All right? So you could, as an association, pass a no smoking rule. I don't know that many associations that have, because there's still enough smokers in our associations that it could be controversial and might be hard to get the votes. But I think if you grandfathered out smokers so that the existing smokers in the complex could continue to smoke, but when they move, then the new owner will not be allowed to smoke in the property. I think that's something we're going to see more and more of, because we're seeing more and more of these secondhand smoke lawsuits. So, great question, June. And not a fair housing question per se, but a very practical question that I think is going to continue in the future. Well, all right. Sonia asks, what can you do if you're in an older complex with no ramps but just stairs? Is an association required to modify the stairs, half ramp, half stairs? Would this create some other issue? Well, Sonia, that's a difficult one. I'm assuming from your question that there's no elevator in this community. If you have no elevator and homeowners would benefit from ramps, and there is some way to make ramps. So you see there's a lot of ifs in my answer here. It's really going to depend on a lot of specifics in your community. That's something that you all may want to look into as an association to benefit your residents, particularly as we all live longer and more of us in advanced years would benefit from having some kind of ramping. On the other hand, if your association doesn't have the available land, the buildings are not configured in a way that ramps are possible, well, that may be an unreasonable accommodation, Sonia. It really depends. A couple of you have asked if there's going to be a PDF of the PowerPoint distributed. That's certainly something that we can make available to you. We will have this seminar recorded, and it hopefully will be on the rhopc.com website by sometime tomorrow afternoon. All our webinars are available. If you click on the News tab on our homepage, you'll see web seminars or webinars listed, and you'll see by tomorrow, I think we'll have 6 at that point. Okay. Kathy asks a question. I have an association that has had an increase in sober living homes that are unlicensed. Are there any changes in laws being considered to regulate these facilities? That's Kathy, that's something that we're all struggling with. Sober living facilities, home daycare facilities, there are special statutes dealing with some of these uses. Again, one of the things that I look at is, first, how did we find out about this? Is there some problem being created? So that may be a great topic, looking at some of these special uses in the future, dealing with some of the special protections that we have in the law for daycare facilities, solar installations, a lot of sort of special circumstances that more and more we're accommodating. Well, let's see. Here's a question. What if modifications causes city code problems? I assume we're talking about building codes. Who is responsible? What would happen or advise the HOA? Well, if a requested modification would violate building codes or create a safety problem, then I think that by definition would not be reasonable. Now, associations, managers, and boards, when somebody asks for an accommodation, you don't give them a blank check and say, go do it. Particularly if it's common area, you're going to want to keep control of those common area modifications. So you have the right to ask them to make sure they get the appropriate permits. If, in fact, it's not going to be done by the association, if, for example, it only affects one home, you can require that they get permits and that it have a certain aesthetic appearance, as long as you're not unreasonably restricting what they're trying to do. Yeah, you don't have to let people do illegal things. That's not going to be reasonable. Another question is, what do I mean by not a protected class when I'm talking to smoking? Well, in the fair housing laws, we have a pretty lengthy list of protected classes. In other words, aspects which one cannot discriminate against just on the basis of that particular aspect. So we have sex, we have orientation, we have national origin, religion, source of income. Okay, that list of all the protected classes does not include smokers. So one of the things in our society that I think has made difficulties in this area is that people view discrimination itself as a bad thing. Not all discrimination is bad and not all is illegal. If I am looking at two hamburger joints and I choose one and choose not to patronize the other, I am discriminating. I am making a choice. But that's not illegal discrimination. It's certainly not immoral discrimination. What we're talking about in this seminar today is illegal discrimination that I would argue also has a morality component, as you can tell from the comments throughout this. So you are allowed to make choices, boards. You're allowed to make choices, managers, but make sure that the choices you're making are dealing with real problems, and they're not making choices that are based on who people are. Let's focus on what people do, not who they are. And then we're going to wind up being in much safer ground in fair housing. Well, I'm sorry for those of you that submitted questions that I wasn't able to answer, but I am at my 1-hour time budget that I promised all of you. The RHO web seminars, we're very careful to try to be very judicious of your time. Your time is very valuable, and we are always limiting these seminars to exactly 1 hour. And by my clock, we have right at 12:30. And I am very, very appreciative of your kind remarks and your great questions. And again, this will be posted on our website for people that were not able to attend today. It'll be on the website tomorrow afternoon at probably after middle of the day on the news tab of our website. Again, please, before you sign off, let me know what you're interested in. Matt and I would love to hear, what would you like us to talk about in our August web seminar? And we'll listen very closely to those comments as we decide the topic. So thanks again. Have a great day, and I hope you found this helpful. Bye-bye.